This is part 5 of criminal procedures. We're concluding here, looking at a jury trial. You have a right to a jury trial under the 6th Amendment. This applies to the states through the 14th. This applies in criminal cases involving serious offenses. And a serious offense may be a sentence of more than 6 months. Now, states have latitude to determine conduct and or details of jury use. The jury must be at least 6. Now, if 6, the verdict must be unanimous. If more unanimity is not required, under the federal rules, requires 12 and requires unanimity. And remember, this section is criminal procedures. Looking at jury selection, a jury must be selected from a representative cross-section. It need not be a representative cross-section. In regards to peremptory challenge of jury members, there is no need to show cause. In sentencing, where the sentence is enhanced by the establishment of specific facts, the jury determines if those facts have been established. In regards to the sentence, a judge can decide whether sentences run concurrently or consecutively. Looking at a plea, you have a right to counsel when entering a plea. Guilty plea must be made knowingly and voluntarily. A guilty plea constitutes a waiver of your right to trial, your right to confrontation, and your right to be free from self-incrimination. There is no need, after you enter a guilty plea, there is no need to determine a factual basis unless you enter a guilty plea and still assert your innocence. In Minnesota, this is known as an Alford plea. You have a right to a speedy trial. The 4th Amendment protects against pre-accusation delay. The 6th Amendment protects against post-accusation delay. The 4th Amendment protects against pre-accusation delay where the prosecution may work to obtain a tactical advantage or harass the defendant or operate not with good faith in their investigation. Again, the 6th protects against post-accusation delay, and this commences at arrest and or formal charge, and the defendant need not know of the charge. The test for a speedy trial and what is reasonable is the length and reason for delay, the defendant's assertion of right to a speedy trial, prejudice to the defendant in delay. Now, if a right to a speedy trial is violated, charges should be dismissed with prejudice. You have a right to a public trial. It must be public unless there's a substantial likelihood of prejudice to the defense or to ensure order. You have a right to a fair trial. Looking at prosecutor misconduct, this may include material misstatements of law and or facts where the prosecutor has contact with the defendant without the defendant's counsel present. The prosecutor gives opinions regarding defendant's guilt and or innocence or makes remarks to the jury to inflame passions. You have a right to confront. There's a right to confrontation. This right to confrontation is physical and or face-to-face confrontation. It is an absolute right unless prevention of that right is necessary to further public policy, such as where there is a child witness. As discussed on the evidence section, testimonial hearsay evidence is barred unless the witness was unavailable and the defendant had prior cross-examination opportunity, or it's not offered to prove truth of the matter asserted. Testimonial hearsay or testimonial evidence is where one should reasonably expect it to be used in a prosecution. The burden of proof and due process, this is beyond, again, this is criminal procedures, this is beyond a reasonable doubt. Now, affirmative defenses, the burden of proof is on the defendant. The prosecution has a duty to prove the defendant's guilt beyond a reasonable doubt, except for except for two affirmative defenses where the burden is on the defendant. Due process in the context of presumptions, there is a permissive presumption and a mandatory presumption. A permissive presumption is where the jury is not compelled to accept the presumption. This does not shift the burden. It is not a due process violation. A mandatory presumption is a presumption that the jury must accept, and this shifts the burden, and we discussed this in earlier sections, to the other party. Now, if a mandatory presumption is to an element of the cause of action, such as the prosecution must prove A, B, and C, and the court gives the jury a mandatory presumption as to element A, this constitutes a due process violation because, again, the prosecution has a burden to prove all elements beyond a reasonable doubt. We're going to cruel and unusual punishment. Cruel and unusual punishment is prevented by the Eighth Amendment. This includes the death penalty for minor offenses, or rape, or the insane, or the retarded, or where the defendant is less than 18 years old, or where there is no possibility of parole for a defendant less than 18 years old. Looking at capital punishment, this applies in the context of a homicide of murder and one aggravating circumstance at the guilt and or penalty phase. And the aggravating circumstance may be lack of remorse or prior convictions. Now, this must not apply to all defendants. So if there's two defendants, one shows remorse, the other doesn't, you can't impute that lack of remorse onto all defendants for capital punishment. And it must not be unconstitutionally vague, such as heinous, atrocious, and or cruel. Looking at double jeopardy prevents prosecution for the same offense after acquittal and or conviction, or multiple punishments for the same offense. To determine whether it is a separate offense or the same offense, if it requires proof of an element the other does not, then it is a separate offense. If there is no unique element between the two, then it is the same offense. That is the Blockberger test. Now, in the context of an acquittal must be in the form of a final verdict, and this may include an error of law. Where does jeopardy attach? Jeopardy attaches in a jury trial when the jury is sworn in. Jeopardy attaches in a bench trial when the first witness is sworn in. Double jeopardy in the context of different jurisdictions. A defendant may be prosecuted by the federal government and by the state government for the same offense, or by two different states for the same conduct, but not by a state-created entity and the state. So you can be tried for murder by Minnesota, acquitted, then tried by Wisconsin for murder, but you cannot be tried by Minnesota for murder and then Ramsey County for murder. Double jeopardy in the context of a mistrial. A mistrial does not prevent retrial. Again, you have to be acquitted. It has to be a final verdict. Now, a hung jury may prevent retrial if the judge grants acquittal instead of a mistrial, or where the prosecution is asking for a mistrial because they cannot find a witness, then double jeopardy attaches, and that completes Part 5 and all of criminal procedures.